I welcome everyone here in Canberra and those live streaming online to this public hearing under Section 21 of the Independent National Security Legislation Monitor Act. At the request of the Prime Minister, I'm conducting a review into the trial and punishment of children for terrorism offences. Today is an opportunity for me and those assisting me to question and hear from government agencies and others who've made submissions. I thank everyone who has made submissions. The program today is publicly available. I will now set out my role and some preliminary thoughts about what I might ultimately recommend at the conclusion of the review. My role, as set out in the Act, is independently to review the operation, effectiveness and implications of Australia's counter-terrorism and national security laws, and having regard to Australia's international obligations, both human rights and security, and constitutional arrangements between the Commonwealth, the states and the territories, to consider whether such laws contain appropriate safeguards for protecting the rights of individuals, remain proportionate to any threat of terrorism or threat to national security, or both, and remain necessary. As Monitor, I'm entitled to see all relevant material, regardless of security classification. I have already had a closed hearing where classified material was referred to, but today is a fully open hearing, and I welcome members of the media here today. My only request is, if you are taking flash photography, would you only do so, please, during the opening statements rather than during questioning. But the hearing is being transcribed and it's being live streamed. Finally, my report to the Prime Minister is due no later than the 1st of December and must be tabled by him in Parliament within 15 sitting days of its receipt. Going along the table, Mr Mooney, my Principal Advisor, my Counsel Assisting, Ms Single of the New South Wales Bar, Mr Tran of the Victorian Bar, and my Solicitor Assisting, Mr Rowe, from the Office of the Australian Government Solicitor. Let me say something more about the review and some of my preliminary views, because we have been working on this matter for some time. We have received submissions, we've analysed them, and for those who haven't seen them, there's a great deal of useful material on my website. First, some definitions. By child, I mean someone older than 10 and younger than 18. 10's the age of criminal responsibility for federal law, and any review of that age is beyond the Prime Minister's reference to me. Young person is 18 to 25 years of age, and when I talk about terrorism laws, I mean federal laws, almost all of which are to be found in the Criminal Code and the Crimes Act, and the Parliament today means the Commonwealth Parliament. Now, as we all know, there are 8 states and self-governing territories. All terrorism trials are heard in state and territory courts, including the 8 children's courts. As you will hear, although the Parliament could cover the field concerning the trial and punishment of federal terrorism offenders and thereby prevail over inconsistent state and territory laws, it has not generally chosen to do so. In court proceedings, state and territory procedural and sometimes substantive laws are picked up as what are sometimes called surrogate federal laws, but often with uncertain results. Finally, there being no federal prisons, all federal terrorism offenders who are sentenced to a term of imprisonment are sent to state or territory prisons or places of detention, as Section 120 of the Constitution envisages. Let me say something about threats. Under the Act, I must consider whether laws are proportionate to threats. So I'll deal with this first. Of course, I will be hearing the expert view from ASIO and other agencies on this topic in a minute, but let me set out my general understanding. The current threat of a terrorist act occurring in Australia remains at the probable level at which it has been set for the last 4 years or so. In my reports last year, I concluded that the credible threat of one or more terrorist attacks will remain a significant factor in the Australian national security and counter-terrorism landscape for the reasonably foreseeable future. While more complex or extensive attacks can't be ruled out and must be prepared for, attacks by lone actors using simple but deadly weapons with little if any warning are more likely. Despite the best efforts of the authorities, there can't be any guarantee that all attacks will be detected and prevented. And there's also the risk of opportunistic, if unconnected, follow-up attacks in the immediate aftermath of a completed attack at a time when police and intelligence agencies are fully occupied in obtaining evidence and returning the attacked locality to normality. I understand, subject to correction, that remains the position. As I expect we will hear next, broadly speaking, terrorist threats in Australia come predominantly from those engaging in radical Islamist action. I contrast that, of course, with the major world religion of Islam, which practices peace. As Mr Justice Haddon Cave, the presiding terrorism judge of England and Wales, said recently when sentencing the Parsons Green bomber, in terms I would adopt, quote, "The Quran is a book of peace, Islam is a religion of peace. The Quran and Islam forbid anything extreme, including extremism in religion. Islam forbids breaking the law of the land where one is living or is a guest. Islam forbids terrorism. The Quran and the Sunnah provide that the crime of perpetuating terror to cause corruption in the land is one of the most severe crimes in Islam. So it is in the law of the United Kingdom," and there ends the quote, but I would add, so it is in the law of Australia. There are also terrorist threats emanating from radical right-wing groups. We have not yet seen children charged with terrorism or related offences from such groups, so I say no more about them now. Since 2014, for people under 18, there have been significant increases, sometimes from zero, in levels of intelligence interest, adverse security assessments, passport cancellations, police investigations and arrests by the joint counter-terrorism teams, which exist now in each jurisdiction, and charges and convictions. I can give some actual numbers of charges and convictions at least. The total number of persons charged with or convicted of terrorism offences in Australia now approaches 100. As of today, 54 people have been convicted, 39 remain before the courts. 5 of those convicted are children, that is, they were under 18 when the offences occurred. 2 children currently remain before the courts, and a number of other children have been charged with non-terrorism offences, although they were caught up in some way in terrorist activity. The sentences range considerably in severity, but have been up to 13.5 years as a head sentence, with a sentence of 10 years and 1 month, or 75% of that head sentence for the non-parole period. We will hear more about Section 19AG of the Crimes Act today, which compelled the sentencing court to impose a non-parole period of this length, and which applies to both adults and children alike. Terrorism offences are, in fact, the most serious federal criminal offences children currently face. Although the absolute numbers remain small, the increases are concerning. Since 2014, therefore, 10% of the total number convicted were under 18 at the time of offending. A further 25% were between 18 and 25. So a third of the total group of offenders were under 25. I have just returned from a visit to the United Kingdom, and they also have been experiencing an increase in the number of convictions of persons for terrorism-related offences who were children when the offences occurred, and it may be we have a great deal to learn from the UK experience. Since 2015, 21 children have been charged with a terrorism-related offence in Great Britain. 14 have been convicted following such a charge. A recent UK Home Office publication stated that, and I quote, "Arrests of those aged under 18 made up 6% of all arrests. That's 27 arrests in the latest year, the highest number and proportion since data collection began in 2001. There ends the quote. Among those convicted, one UK offender, the then 14-year-old boy who inspired the would-be Australian Anzac Day bomber in Melbourne, was given a life sentence with a minimum non-parole period of 5 years. Another was given a life sentence with a minimum non-parole period of 11 years. Other sentences have included 24 months detention and training or a 12-month intensive referral order. Australian courts over the years have steadily increased the sentences being imposed for terrorism offences, many of which have maximum penalties of life or 25 years imprisonment. There have been sentences of more than 10 years for people who were children at the time they committed the terrorism offences. In the important case of MHK, the Victorian Court of Appeal recently made clear how seriously it regards this type of criminal offending, which it described as the scourge of terrorism. The court said this: "In the present case, the respondent was only 17 years of age at the time of the offending. Ordinarily and in general, the youth of an offender is an important mitigating circumstance. It's relevant to an assessment of the moral culpability of the offender, as the law recognises that the immaturity and impressionability of youth may be, and commonly is, an important contributing factor to the involvement of a young offender in the crime for which that offender is to be sentenced. In addition, the law regards the rehabilitation of young offenders of substantial, if not primary importance, not only in the interests of the offender, but also in the interests of the community. On the other hand, it's recognised that those principles need to be appropriately moderated where, as in a case such as this, the offender has been involved in serious and dangerous offending." And then their honours conclude, "In the upshot, as we have stated, the offending in this case was particularly serious. Notwithstanding the age of the appellant and the steps he has taken to rehabilitation, the principles of general deterrence and denunciation are of primary importance. Unless appropriate weight is given to those considerations in a case such as this, the criminal justice system will not have sufficiently discharged its duty to properly express the community's outrage at the conduct of the respondent and to deter other like-minded individuals from indulging in the same or related conduct." May I then turn to the three groups of federal laws raised in my review. There's Section 15AA of the Crimes Act, which sets out a presumption against bail for all those charged with particular terrorism offences. There's Section 19AG, which for most terrorism offences requires the court, for adults and children alike, to fix a minimum non-parole period of at least 3/4 of the head sentence, and Section 20C, which provides in effect that a child charged with a Commonwealth terrorism offence may be tried, punished or otherwise dealt with as if the offence was an offence against the law of a state or territory. I accept that when most terrorism laws were enacted, there was no particular consideration given to children being convicted of those offences. As the progress of this review to date has already shown, there are troubling and unforeseen problems in the juvenile justice system, often because of considerable differences in trial and punishment, depending upon which state or territory the federal prosecution takes place in. Let me give a couple of examples. The role of the Children's Court in the various jurisdictions differ quite significantly from each other. Potentially, offending which would be dealt with in the Children's Court in one state or territory would be dealt with in a general court in another, causing material differences in the way the matter is conducted or resolved. Second, there's the scope for significantly different sentencing outcomes. All children's courts have caps on their sentencing powers of some sort, which would in any serious case mean much shorter sentences than would otherwise be imposed. And third, there is inconsistency in the circumstances in which juvenile sentencing principles will apply to a child sentenced for crimes as serious as those relating to terrorism. Those inconsistencies require explanation, analysis, and at least some reform. We've now undertaken the analysis of 9 different legal systems, including 8 different children's courts. I can understand why reform might have been put in the too hard basket over recent decades. However, the Prime Minister has requested me to undertake this review, and I intend to fully answer all the questions the review throws up. I have been fortunate to receive a number of submissions from government, Commonwealth, state and territory, human rights bodies, professional associations and the public. And those instructing me have done an excellent summary of the submissions, which is available at the back of the room. The submissions, of course, reflect a range of views, but can I offer the following? First, in relation to 19AG and 15AA, there's a good deal of productive discussion in the submissions about whether they comply with Australia's international obligations, and more generally, whether they're appropriate in any event to apply to children. Most non-government submissions recommend that 19AG in particular not apply to children. Somewhat unusually for an INSLM review, I've had the benefit of assistance from many state and territory authorities. I have a formal submission from New South Wales Justice. I have other submissions just arrived or on the way from state or territory governments. Not all states and territories have chosen to provide a formal submission, but ministers, courts and agencies have been extremely generous in the time and effort devoted to consultation with me and those assisting me, and I'm grateful in particular for the assistance in relation to the detail of state and territory laws. Finally, while I've been assisted with the detail of the law in particular jurisdictions, the submissions to this review generally offer more limited guidance on inconsistencies between them. It appears to be common ground that arbitrary discrepancies between jurisdictions are generally undesirable, although some of that comes with federalism. Understandably, given the small number of juvenile terror offending to date and the complexity of comparing different juvenile justice systems in the abstract, the submissions have generally not engaged with the fine detail of potential inconsistencies. The Human Rights Commission has recommended that there be a comprehensive survey of state and territory laws and rules to identify inconsistencies. I do intend to identify such inconsistencies as far as I can. Indeed, submissions from the Commonwealth DP have been particularly helpful, and I should here acknowledge my gratitude to her and her staff. Then can I turn to some preliminary views, which I'll state shortly and look forward to discussing during the day. My preliminary view is that the inflexible three-quarters rule set out by 19AG should not apply to children. My reasons include the following. A number of submissions persuasively argue that 19AG breaches the Convention on the Rights of the Child because it precludes any judicial discretion in setting the non-parole period. They point out it is no answer to say the court has a discretion on setting the head sentence. Commonwealth sentencing law requires the court first to set the head sentence, and it's impermissible to do this by reference to parole, whether set by 19AG or at the court's own discretion. Now, that conclusion is not surprising. In other areas, for example, people smuggling and a current bill in relation to possession of weapons, there's a carve-out for children in relation to mandatory head sentences. It appears the reason for that carve-out for children is to avoid breaching Australia's obligations under the Convention. I'm not suggesting that any non-compliance was deliberate at the time 19AG was enacted, only that now it's being used against children, and as such it needs reform. I also consider, on the evidence I've received so far, that it's counterproductive to have an inflexible rule like 19AG in every case, particularly when it comes to children. Look at Britain. Children have been given life sentences for terrorism offences, but relatively short minimum non-parole periods, in which case it still remains for the offender to demonstrate they should be released on parole. In Australia, they would need to demonstrate their suitability to the Commonwealth Attorney General, who personally considers all parole applications by terrorism offenders. 15AA. I will also need persuading that 15AA is not in breach of the Convention, although there may be more room for differences of opinion here, because the decision whether or not to grant bail is ultimately at the discretion of the court. The primary area of debate appears to be the provision may preclude the best interests from the child from being I emphasise A, primary consideration. The English position may also be instructive. There is a presumption in favour of bail for everything except murder and attempted murder, but those charged with terrorism offences almost never receive bail. There may be some merit in a carve-out for children from the exceptional circumstances requirement in 15AA. This could be replaced with language similar to that used in the control order legislation, where the best interests of the child are a primary consideration, but the paramount consideration is the protection of the community. That approach was used in the control orders legislation by the government at the suggestion of the PJCIS. If used in relation to 15AA, it might ensure compliance with the Convention, but still allow the bail authority fully to protect the community. In practice, it may be that bail's not given any more often for children in terrorism cases than it has been to date. And finally, I hope to better understand the COAG decision last year concerning the harmonising of state and territory bail laws. It's possible this has overtaken anything I might recommend. May I finally move then to say something about 20C. That's the most difficult part of the review. As I've mentioned, the legal framework is complex. There are 8 different legal systems plus the Commonwealth system. Although the concept of the Commonwealth making clear when its laws are to prevail is simple, in practice it isn't that simple. Even the DPP is not absolutely sure what aspects of state and territory law might be picked up on some occasions. The submissions by the DPP expertly describe the complexities and have been of immense help. And the submissions show there are a range of inconsistencies. Let me mention a couple. First, there's no consistent definition of a child or young person. Second, there seems to be potential for significantly divergent sentencing outcomes. So, for example, in Queensland, there seems to be an absolute cap of 7 years in certain circumstances where, as I explain in more detail in the written version of these notes, in the MHK case, it may well be that the sentence of 11 years Victorian Court of Appeal imposed would have been capped at 7 years had the case be heard in Queensland. There are jurisdictional differences as to whether and when a matter may be uplifted to a higher court. Usually, though, state and territory children's courts have much lower jurisdictional limits about the length of the custodial sentences they can impose. And then there is the complexity about whether people are tried according to law or according to juvenile justice principles. In my view, it's one thing to have minor discrepancies in federal sentencing based upon different state and territory laws and procedures. Major discrepancies call for explanation and substantial justification. As a matter of principle, such major discrepancies are likely to be wrong. The High Court, in a matter of PHAM, P-H-A-M, in 2015 said this: a federal offence is in effect an offence against the whole Australian community, and so the offence is the same for every offender throughout the Commonwealth. In the absence of a clear statutory indication of a different purpose or other justification, the approach to the sentencing of offenders convicted of such a crime needs to be largely the same throughout the Commonwealth. Further, as Chief Justice Gleeson said in Wong, the administration of criminal justice functions as a system which is intended to be fair, and systematic fairness necessitates reasonable consistency. And there ends the quote. At a policy level, the community would have a legitimate sense of grievance if it thought that essentially the same conduct constituting a federal terrorism offence could result in a very different sentencing outcome simply based on where the proceedings took place. Equally, a co-offender or a person convicted of the same offence based on similar conduct who received a markedly different sentence would have a legitimate sense of grievance and possibly also a good ground of appeal. I will therefore be recommending there be much greater consistency throughout Australia, regardless of where the matter is prosecuted. The precise detail of that is a matter for further debate and thought, including today. All of this is consistent with the Prime Minister's letter to me referring this review, which says the following. Given the procedures regarding the prosecution of children for terrorism offences are different in each state and territory, the Commonwealth should consider whether to implement arrangements to ensure a consistent approach to the prosecution of children for Commonwealth terrorism offences. There ends the quote. There are two more topics to deal with. The first is the question of certainty. A fundamental issue is even working out precisely which mixture of federal and surrogate federal law applies. As the DPP supplementary submission frankly states, in many instances it's simply unclear what state and territory laws are in fact picked up and applied, because the Commonwealth Parliament hasn't indicated explicitly its intention to cover or not cover the field or otherwise to prevail over state or territory laws. For example, the supplementary submission, which is on the website, indicates uncertainty as to which orders short of imprisonment, which could be made by the Children's Court in its state or territory jurisdiction, whether they are equally available as surrogate federal laws. I share these doubts. Yet these are matters of real consequence for both prosecution and defence, particularly in advising the accused. Federal criminal law is a specialised field in any event. The subset of federal juvenile criminal law is even more specialised. It's just not satisfactory that competent lawyers are unable to say with any certainty when advising their respective clients what result might occur as a matter of the powers of the court. This doesn't reflect on the DPP and other submitters who are deservedly recognised as experts in the field. Rather, it reflects poorly on our system of laws as a body of law that ought to be accessible to advisers and the public. These matters are real and they're current. In a recent case in New South Wales for a federal juvenile terrorist offender, a Supreme Court judge twice asked the sentence hearing be relisted for further argument, in part because the applicable law and consequences were so unclear. I will be recommending reforms to clarify the law, as it's fundamental the law should be reasonably easy to ascertain. And may I then turn finally to the role of children's courts. So, as I mentioned, there are 8 of these. And let me be clear at the outset. Children's courts are at the front line in juvenile justice. They do important work in often difficult conditions, and with respect, I only have praise for that work. On the other hand, the experience in England may be instructive, even bearing in mind Australian federalism, and it suggests that a Supreme Court or District Court judge and jury should hear all or almost all terrorism cases. Let me explain. In England and Wales, all terrorism trials are case managed centrally, initially by the presiding terrorism judge sitting at the Old Bailey in London. The trials are then heard either by that judge or a cohort of 20 of the most senior judges chosen by the judiciary themselves. And the way some of those judges explained the reasons for that to me are fourfold. First, there's a public interest in prompt case-managed terrorism cases by the most experienced judges so as to avoid, if at all possible, error leading to mistrial or retrial. And so the public have extra confidence in the conduct of the trial and the appropriateness of the sentences passed. Secondly, terrorism cases stand apart from normal crime because of their exceptional seriousness to society as a whole. After all, an element of most terrorism offences is that the offender sought to intimidate a government or the public or a section of the public, and to this extent the concept of the federal offence being against the Australian community is particularly apt. Third, very often terrorist cases involve national security material or personnel, thereby requiring exceptional orders to close the court for a period of the trial and make orders ensuring that national security material or information isn't inadvertently released, but understandably the media have an interest in ensuring those orders are kept to a minimum. Fourth, it's quite often the case there's a vast amount of material discovered by the prosecution, which, as one judge put it to me, is beyond the capacity of a single human brain to analyse and therefore requires search by computer, often complicated because the original files are encrypted or in a foreign language, but which requires at an early stage the active involvement of the case managing judge to ensure the search terms used by the Crown at the request of the offence are apt. For all of those reasons, I expect to recommend that most, if not all, terrorism cases should be tried by experienced judges in Supreme, County or District Courts, with a jury, as Section 80 of the Constitution requires for all trials on indictment. Of course, it will be a matter for each court to decide which judges to allocate. To conclude, because we are talking about courts invested with federal jurisdiction, there's no conceptual or constitutional problem with the Parliament amending the Judiciary Act to provide, for example, that for certain offences involving children, only particular courts have jurisdiction. Already New South Wales and Victoria have passed their own laws, or have a practice note, which means that most terrorism cases cannot be heard by their respective children's courts. Where to draw the line nationally won't be easy, but the mechanism might be threefold as follows. First, all terrorism offences with maximum penalties of more than a certain amount, quite what that amount may be open to debate, must be heard with judge and jury in Supreme, District or County Courts, and as I mentioned, New South Wales and Victoria have taken some steps already in this regard. Second, for all remaining matters, the Children's Court retains jurisdiction, but whether it exercises it should be determined by applying further tests. For example, is the matter proceeding summarily with the consent of both the prosecution and the accused, which sometimes happens? If so, it might remain. Is there an adult co-accused? If so, it should be sent to the higher court. And thirdly, otherwise to ask, as it was in England, whether, taking the Crown case at its highest at the beginning of the case, is it likely there will be a conviction which will result in a sentence of detention or imprisonment of more than a certain period, say 1 or 2 years? If so, then only a state or territory court capable of awarding a higher penalty should have jurisdiction under the Judiciary Act to hear and determine that federal juvenile terrorism case. That would also mean the child would have the benefit of the constitutional guarantee of trial by jury in Section 80 of the Constitution. Pausing there, in England, defence counsel said they would always recommend that their clients had the benefit of a jury trial, and except in the Queensland Children's Court, trial by jury is not available. All other children's courts only hear matters summarily, judge, no jury. These and other matters will be discussed today and considered as part of the review in coming months. Now, a copy of these remarks is now available along with the summary to people present here and including members of the media at the table at the back, and if we need more copies we can make them available. Thank you for listening to that long opening, and I now invite opening remarks, and I think the Acting Director General of Security, you're going to begin.